Good morning, good afternoon, everyone. We're just going to go ahead and get started. Thanks so much for joining us. My name is Courtney Chappell. I use she, her pronouns, and I'm the VP of Programs here at AAPIP. We really appreciate you all taking time to join us today for this briefing about birthright citizenship and what comes next after the Supreme Court's decision last month. So just as quick background, for those who might be new, AAPIP, we are a national affinity organization that serves as a bridge between Asian American, Native Hawaiian, and Pacific Islander communities and philanthropy. Our mission is to expand and mobilize resources for A and HPI communities to build a more just and equitable society. We are membership-based. We have individual members, institutional members across the country, and we have 11 chapters that serve as sites of place-based activism. And together, we really hope to kind of cultivate deeper connections and belonging, build power, and engage in systems change work to ultimately redistribute wealth in more equitable ways so that all of our communities can feel safe and can thrive. So as part of our philanthropic advocacy work, we strive to educate the field about the issues and priorities facing the ANHPI community, and especially now, with the political landscape shifting constantly and the attacks on our communities becoming more numerous, more vicious, and mean-spirited, advocacy has really taken on even more urgency. And we want to be as responsive as possible, right, to help organize the sector and collectively shift or redirect funding priorities and resources to where they are most needed. So as you all know, on his first day in office, President Trump signed an executive order attempting to unlawfully deny citizenship to children born in the US to parents who are either undocumented or who have temporary immigration status. And along with many of his executive actions, this launched a months-long legal battle with several lawsuits being filed and one of the procedural issues reaching the Supreme Court. And just make no mistake, right? This is part of this administration's just broader attack on immigrant and refugee communities to cause confusion and fear, instability, to divide communities. So as these legal battles are playing out, we are also witnessing increased surveillance and even government-sanctioned violence against communities and protesters across the country. These workplace raids and the targeting of immigrants and refugees has had just a devastating impact on our families, our neighborhoods, and our communities. So stepping back, this brings us to one of the fundamental questions, right? What does it mean to be a citizen? How has citizenship been defined and changed over time based on prevailing social values, political context? How has birthright citizenship become kind of the cornerstone of American democracy, American inclusion? And then finally, what happens now with the multiple cases challenging Trump's EO and the Supreme Court's limitations on nationwide injunctions? What does that mean? And with Congress just pretty much rubber stamping Trump's political agenda, it's really the lawyers and the organizers on the ground who are stepping in to serve as guardrails against executive overreach and abuse of power. And philanthropy absolutely has a key part in supporting that work. So we hope to answer some of these questions today and leave you all feeling activated and just recommitted. And I'm really honored to spotlight two inspirational leaders who have been steeped in advocacy and movement work for decades. We have Aarti Kohli, the Executive Director of Asian Law Caucus, which is one of the organizations that has sued the Trump administration over the Birthright Citizenship EO. And Aarti will be talking more about the context and providing an update about the case and what comes next. And we have Ivy Suriyopas, the Vice President of Programs at Grantmakers Concerned with Immigrants and Refugees, GCIR, which is a national philanthropic mobilizing org. And Ivy will be sharing the history of citizenship along with GCIR's Who Gets to Be an American Timeline project. And I also just want to thank GCIR and Philanthropy New York for co-sponsoring this briefing alongside AAPIP. We're just really grateful for your partnership. So feel free to drop in the chat or use the Q&A function just to ask any questions throughout the conversation or any thoughts. And we have some time at the end to answer those questions as well. So with that, I'm going to turn things over to Ivy.
Thank you, Courtney. Good afternoon, good morning, everyone. As Courtney shared, my name is Ivy Suriyopas. I am the Vice President of Programs as well, but at Grantmakers Concerned with Immigrants and Refugees, or GCIR for short. And we seek to mobilize money and power from philanthropy to the immigrant and refugee justice movement. And among the different bodies of work that GCIR engages in, such as webinars that we're on right now, we publish information resources. And one of them is this timeline that Courtney referenced. So we have a timeline project where we're really trying to shift the conversation on migration and really open up the conversation. And this one in particular really kind of studies or interrogates the question of who gets to be an American. And it really has shifted over time. And a lot of that is due to the struggles from historically marginalized groups over the course, since the founding of this country, which, we're celebrating the 250th anniversary next year. And so where will we go for the next 250 years? And I think that really is informed by where we've been. So to touch base on just how we arrived at birthright citizenship in this country, I'm going to be talking about some factors that have kind of influenced how we arrived at birthright citizenship. Among them are obviously migration to, from, and even within the United States, the movement for Black liberation, both for enslaved African Americans and those who were free, and how that relates, interestingly, to Haitian independence, and obviously eligibility for citizenship. And again, that question of who gets to be an American. So when we look back at migration to the United States, classical history will talk about different waves of migration, right? Towards the late 1770s through the 1820s. So really, when the country was very nascent, that first quote unquote wave of migration was mostly from Britain. And then towards the middle of that century, in the 1840s to 50s, there was another congregation or movement of migrants into the country, mostly Irish and German Catholics. And that actually spurred a reaction from Protestants, a backlash from Protestants here in the US, culminating in what became known as the American Party, also known as the Know Nothing Party, also known as the Nativist Party, which was really anti-immigrant, anti-Catholic, and became the first major party of the third party of the United States. And at its height, there were members of Congress, 8 governors. They controlled 6 state legislatures and thousands of local politicians, including former President Millard Fillmore, and really reflects, I think, where we are today in terms of the MAGA party and the regime that we have in power. And then after the Civil War, there have been subsequent waves. Towards the end of the 19th century, we had, as many know, a wave of those coming from Southern and Eastern Europe, from Italy, Greece, Slavic countries, Poland, and Jews from the Russian Empire. And then after the 1965 Act, there was a wave that we're still currently in, largely from Latin America and Asia. So just to back up a little bit, when we think about the formation of citizenship in this country, it's important to note that citizenship was relegated to the states. In like the Articles of Confederation, shortly after this country was founded, that power was decentralized, and courts all over the country were responsible for delineating who got to become citizens. And that was within the purview. The limitation that Congress gave was that citizenship was limited to, quote, free white person, right? And there were other guardrails about, years of residency and other, requirements such as good moral character and allegiance to the Constitution and so on. But another factor that's important to note when it comes to how we arrived at birthright citizenship is the domestic population, specifically of the growing population of free African Americans, right? From between 1790 and 1870, that's an 80-year time span, the population of African Americans grew from about 60,000 people to nearly 500,000. That results in about 1.5% of the total population. That seems like a small amount, but that actually represents a 720% increase over the course of less than a century. And that really instilled fear, quite frankly, in the white majority. That, combined with Haitian independence in 1804, there was a real fear that enslaved African Americans would feel inspired to fight for their liberation and create an even greater population of free African Americans. And so there was a reaction to that, like a swinging of the pendulum. And in 1804, the same year as the Haitian independence, you had the start of Black laws. These laws were used to stifle migration of free African Americans to certain states and reduce their status essentially to denizens, people who occupy that middle status between full membership, native US citizens, and foreign, full exclusion, and really try and put them in that liminal space. African Americans responded in different ways. One way, free African Americans in particular, some opted for emigration, right? So for instance, Paul Kohli, who was a mixed race Black man, Indigenous and Black, tried to create an immigration movement and took a delegation of 40 free African Americans to Sierra Leone in the hopes and the belief that the only way that free Black people could really be liberated is to leave the United States altogether, because US states, the white majority, had made life so untenable for free African Americans. And ironically, that actually inspired the creation of the American Colonization Society, or ACS. The difference, though, is this was a white-led organization that was federally funded initially, that sought to resettle free African Americans overseas in places like Liberia and so on. And the idea was it appealed to Northerners who wanted abolition, but who did not want to integrate with free African Americans. It also appealed to Southerners who wanted to mitigate the agitation amongst enslaved people and make it so that if they were to seek freedom, then they would have to leave the United States. And ACS actually worked with the state lawmakers who passed these Black laws. So you really see this complicity of different arms of the government really trying to figure out how to remove free African Americans from this country and not recognize them as citizens in this country. And so another reaction for those who were not interested in immigration was Black organizing, right? In 1817, so a few years after Paul Kohli led his delegation, nearly 3,000 men gathered in a church in Philadelphia, and they denounced the American Colonization Society. They said the US was their land as well, and many died on both sides of the revolution for the principle of freedom and their own liberation. And so you saw a pushback against this idea of oh, we should leave the US. They said, no, this is our country. We bled for this country. We should be recognized as such. Then you cut to a few years later in the 1830s, where after much resistance, Congress actually passed the Indian Removal Act and forcibly relocated 5 tribes, the Cherokee, Chickasaw, Choctaw, Muskogee Creek, and Seminole tribes, from modern-day Georgia, Mississippi, Kentucky, Tennessee, and Alabama, forced them to walk 1,200 plus miles along what became known as the Trail of Tears to Oklahoma Territory, or Indian Territory, rather. And that led to as many as 100,000 people walking along that trail. And the idea was that that land would be set aside for them, quote, as long as grass grows and water runs. Of course, we all know that the federal government eventually opened up portions of that territory for white settlement later in the 19th century. That law, the Indian Removal Act, also explicitly denied them US citizenship. And so when this Trail of Tears happened and when the Indian Removal Act was passed, the Black organizing continued, and there was an analysis from the free African American delegates at these conventions that were now happening at state and national levels about how to strategize for their socio-political rights. And specifically in the 1831 convention, delegates realized that the federal government could relocate tens of thousands of Indigenous Americans. African Americans faced a similar threat of forced removal. And so they continued to organize and advocate and recommend that they be admitted to the same rights and privileges as any other American citizen. And you saw the early formation of the National Equal Rights League, which is a predecessor to the NAACP. And then you also saw advocacy that was happening roughly around the same time as this organizing. So there was an abolitionist, William Yates, who wrote a legal treatise that argued that African Americans couldn't be removed from individual states, based on Black laws, or the U.S. country as a whole, because they have a claim to the U.S. They have the right to enter and stay, and they are protected from expulsion. And his treatise eventually was made law in the 1866 Civil Rights Act, and also formed one of the fundamental principles of the 14th Amendment. Other advocates include Martin Delaney, who wrote a book, who for the first time, I believe, insisted that African Americans had birthright citizenship. Frederick Douglass, a few years also around that time, declared by the principles of the Declaration of Independence, Constitution, facts of history, admissions of American statesmen, hardships and trials that they endured, and courage and fidelity displayed by their ancestors in defending the liberties of and achieving independence in this land. Therefore, African Americans are U.S. citizens. And the National Equal Rights League also eventually promoted full citizenship for all African Americans, particularly as compensation for their military service in the Revolutionary and Civil Wars. Now, in addition to the movement for Black liberation, you also had immigrants coming into this country. As I shared, the second wave that came into this country, larger groups of migrants who came to this country were largely Catholics, Irish and German Catholics. And during that time, there was, and again, to reiterate, states had a very decentralized and easier ability to help people become citizens. And so what you had during that time was a very expansive view of immigrants, even as we're like navigating the tensions with what citizenship means for African Americans, free and enslaved. And so, for instance, you had during that time, before local elections, friendly judges would actually expedite naturalization documents for German and Irish immigrants for free in exchange for their votes. And you also had as many as 20 to 30,000 Irish immigrants naturalized in a period of 6 weeks before the 1868 election. And then on the other side of the country, in the states in the West and the territories, they were trying to attract new residents by permitting non-citizens who declared their intent to become citizens. They permitted them to vote. So they were called declarant aliens. So essentially, you didn't have to be a citizen at the time of voting. So long as you moved there and promised to naturalize, then you had the right to vote. And you had this basically decoupling of citizenship and the right to vote during this time. And then something also of note, towards the middle of the century, we had the US-Mexico War that ultimately led to the US acquiring 55% of Mexico in exchange for $15 million. And per the provisions of the Treaty of Guadalupe Hidalgo, the United States promised US citizenship to 75,000 to as many as 100,000 Mexicans in the Southwest. And what you had was, between that and the annexation of Florida and Louisiana, as many as 100,000 people, Spanish-speaking residents, becoming US citizens in a very, very short period of time. Something of note is that also around this time you had women's organizing. Seneca Falls Convention took place, where there were 11 resolutions on women's rights, and including one resolution demanding the right to vote. If non-citizens can vote, why couldn't women? But it would take another 70 years for those demands to be realized. And then also I wanted to share that with respect to those who were enslaved, there, as we know, one of the major causes of the Civil War was increased tension over the fugitive slave laws. And the federal government, Congress passing a law requiring northern states to turn over African American refugees back to the South to return them to enslavement. And so you had African Americans fleeing to Mexico, to Canada, and to other free parts of past US territory, however they could. And really this together with the Supreme Court decision, Dred Scott versus Sanford, which declared unequivocally that Black people are not US citizens, that ultimately led to the Civil War, in which we were fighting over the question of slavery and to some extent the question of, like the status of African Americans. I also wanted to share that President Lincoln passed two laws to actually encourage immigration, including the Homestead Act, which provided 160 acres of free land for anyone who was willing to live on that land and make certain improvements. And that anyone who was a U.S. citizen or declarant aliens, those who are non-citizens who promised to become U.S. citizens, could qualify for this. So it's a stark contrast to the kind of environment that we have right now. In the middle of the Civil War, we passed the Civil Rights Act of 1866, which I already shared. William Yates and his treatise on African American or citizenship for African Americans formed the basis for that law and protect all citizens equally, and it established birthright citizenship, which was ratified with the 14th Amendment 2 years later. Should note that earlier this week was the 157th anniversary of the Secretary of State declaring the 14th Amendment as law. The 14th Amendment says all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the U.S. And of the state in which they reside. No state shall make or enforce any law which shall abridge privileges and immunities of citizens in the U.S., nor shall any person be deprived of any life, liberty, or property without due process, nor shall any person within its jurisdiction, nor shall it deny to any person within its jurisdiction the equal protection of the laws. So it's just important to reiterate the language of the 14th Amendment. I'm coming up at time, so let me just rush through really quickly a few other additional points. So when Congress extended eligibility to naturalization from white people to African Americans in 1870, after the Civil War, they explicitly did not say, oh, just striking white from the language, free white persons. They just extended it to aliens of African nativity and to persons of African descent, because there was already fear that Chinese immigrants would try to naturalize. And then you saw that was tested just 8 years later in a Ninth Circuit case called In Re AAPIP, where individuals of Chinese descent were found to be ineligible to naturalize because they were neither white nor of African descent. We also know about the Chinese Exclusion Act, which rendered Chinese nationals unable to naturalize. And then in years later, other people of other racial groups tested whether or not they were white or Black, but more often than not white, to qualify for citizenship. And then finally, I'll maintain two more points. Of course, we know Wong Kim Ark at the end of the 19th century in 1898 was a seminal case where a US-born man of Chinese descent tried to challenge his exclusion from being recognized as a citizen. And the Supreme Court sided with him, saying that even though his parents were themselves ineligible to become citizens, he, as someone who's born in San Francisco on US soil, was a citizen. And interestingly enough, the Department of Justice actually selected him as a test case because they thought they would win and didn't expect the Supreme Court to rule in his favor. And then finally, the last piece I wanted to share and just kind of close the loop. Congress did not standardize naturalization until 1906. Until that point, more than 5,000 state naturalization courts existed across the country. And it was at that point where they established and required documentation of lawful entry or admission as a prerequisite for naturalization. And what that led to was a hiccup because a lot of people who tried to enter the United States at that time did not have entry records. And so in 1929, Congress established the Registry Act of 1929 that basically allowed for the retroactive creation of admission records for anyone who came into the country before a certain date. And that was basically the first legalization and pathway towards legalization this country has ever had. And it's been updated 4 times. And groups like Churla and others have been advocating for it to be updated one more time as recently as last year. And apologies for going a little bit over time.
You're all good, Ivy. Thank you so much for just providing that historical context. I think it was super helpful. And for me, I know some of these milestones and dates, but putting it within sort of that, framework really just drives home just the complicity of our government in promoting like policies, many of which are explicitly racist, right? Just to hold on to power and and they do this through like citizenship and naturalization, things that you just mentioned. So it's just, again, driving that point home. And I think that helps us better understand how we got to where we are today. So with that, I'm going to turn it over to Aarti to talk about the current litigation challenging the executive order.
Great.
Aarti?
Yeah, thank you. So I'm Aarti Kohli. I'm the executive director of the Asian Law Caucus, and I'm so glad to be here with you today. And I will try to keep the legal information not too dry or boring. Let me see, what I can do. So there's a lot at stake for us in this moment. As you all know, the whole world has shifted. And one of the first things that the Trump administration did on Inauguration Day, next slide, was issue the Birthright Citizenship executive order. And so, as Ivy shared, the 14th Amendment gives us significant protections. And one of the main things it says is that everyone who is born in the United States and subject to the jurisdiction of the United States is a US citizen. And it's been long-standing practice even before the 14th Amendment for many people, but the 14th Amendment and Wong Kim Ark certified that this is going to be the law. And then actually Congress even passed a law mirroring the language of the 14th Amendment. So people were quite shocked when the president, issued that executive order. The lawyers were like, this is so confusing. This is just well-established law. But we know that, this was both political theater. It was there to instill fear and also to try and push the law in a different direction. So we filed a lawsuit on Inauguration Day with the ACLU and the NAACP Legal Defense Fund. And we anticipated that he had been saying he would do this order, so we were ready. In terms of the impact, I'll tell you a little bit more, but just, before I get into the legal pieces, every American is going to be affected by this. It's not just the folks whose children won't qualify as birthright citizenships because of the bureaucratic process it's going to now entail if this executive order ever goes into effect. It also would create a whole generation of stateless children and an underclass which is, already building between a greater gap between the haves and the have-nots in the United States. Okay, let's go into the next slide. Sure. Yeah, I can make the slides available. So I'm just gonna give you a sense of the timeline of cases, and then I'll go into detail about a couple of these cases. So the executive order is issued. We file a case on behalf of an Indonesian community support group in New Hampshire. That's January 20th. It's not on my timeline because I couldn't fit all of the cases on my timeline, but there were a couple more cases filed immediately in the next few days. There was a case filed by the states, two cases filed by the states, one in Washington by Washington State, another by New Jersey, which California and a bunch of other states joined. So all in all, 22 state attorney generals sued the Trump administration. And then there was a case filed by CASA, which is and ASAP, which is an asylum access organization, and on behalf of their members. So those cases were filed just within a few days, and judges started issuing injunctions. Actually, why don't you go to the next slide? I can tell you a little bit more about our case. So we filed our case in New Hampshire, and actually, just to be accurate, it wasn't the first successful challenge to the order, but it was one of the first. The first one was actually in Washington State. It was an early win but our judge was quite smart. He knew that can you go back to the old slide? He knew that the Supreme Court does not like this idea that a judge can stop the president from doing something. A district court judge can stop the president from doing something all across the country, even if it's blatantly wrong or unconstitutional. So he limited the relief in our case to our plaintiffs. But in the other cases, in the attorney general's cases and the CASA case, those judges said, hey, we have the power. This is wrong all across the country. It's blatantly unconstitutional. And so we're going to issue a decision for the whole country. And that is the case. If you see here, Trump v. CASA on June 27th. So we're talking, look at the timeline. It's 6 months. This actually for courts is a very fast timeline. And so let me tell you about the big Supreme Court opinion, because I'm sure it was pretty confusing when you heard about it. So can you fast forward 2 slides? Okay, so this is like the game that's being played here. The Trump administration says, oh, you judges want to stop us from doing things across the country? Well, we're going to tell the Supreme Court we want them to stop you all. And so we're not going to appeal on the merits. We're not going to appeal whether we're right on birthright citizenship or not. What we're telling the Supreme Court in an emergency appeal is they got to stop you because you're messing with the power of the president. So the Supreme Court could have taken a more reasonable approach, but they basically agreed with the Trump administration. And so in a 6-3 ruling, Amy Coney Barrett, who in a very professorial, very long opinion, was explaining about how the courts don't have this, the district courts didn't have this power, over 100 years ago, so they don't have this power now. And there's a lot of opinions on whether even her argument is correct. And meanwhile, you had the dissenting judges, Sotomayor and Justice Jackson, issuing opinions being like, hello? Are we talking about the same thing? Because you're basically allowing this administration to go forward in implementing an executive order that is blatantly unconstitutional. You're not even talking about the merits of the case. You're letting them play games. And you have such disdain for these district court judges. They're trial judges. They're the ones who determine the facts. They often take a really long time. They're very deliberative. And by the way, I don't know if you're aware, but these judges are getting death threats. Our judge in our case got a death threat. They're not all progressive judges. Our judge is a Republican appointee. And so it's just really interesting the disdain that the court has. And the interesting thing is they were like, well, those judges can't issue nationwide injunctions. But of course, the Supreme Court can always do that. So they didn't limit their own power. They're just limiting the power of the lower courts. And what they basically said is so they left some windows open. They said, if a judge feels like, hey, in order to give complete relief to the plaintiffs, I have to issue a universal injunction, then they still can. And basically what their decision meant was in the 22 states where there were injunctions, that was fine. Those babies in those states are protected. In other states, no. Like the members of certain organizations of AAPIP and or CASA are protected. And they also said this, okay, you can't just go in and get a universal injunction as an individual. but you can go and file a class action, which is having a group of people who are similarly situated say, look, we all need relief. And then you can also still file cases under this very technical law called the Administrative Procedures Act, which I can tell you a little bit more about later. Okay, so what happens? We had a feeling that, and then the court says this: Trump administration, you have to wait 30 days before you can put this executive order into effect. 30 days from the day that we decided. And so it was June 27th, and the clock was ticking. We had a feeling that the court would, we knew this was a possibility. We didn't think they would go, they would wholesale by the Trump administration's argument, but we were concerned. So we were ready to file a class action, and we filed the same day because we were very worried about that 30-day window. We had 30 days to stop this executive order from going into effect. And so we, asked the judge to rule right away and to certify our class. So can you go to the next slide? So that's this case, Barbara v. Trump. And so the judge certified a provisional class, which is like, yes, I think this is going to work. It was interesting because our class had included parents and babies, but the judge actually limited the class to babies because I think he was concerned, and I think it's true, that the Trump administration would have said, well, these parents are not all similarly situated. They have different immigration statuses. For example, one was on a student visa, another was on as an asylum seeker. So he was worried about more games that the administration would play. And so then we got another universal injunction. And so July 10th, which is before the 30 days is up, everyone is protected again in the country. And then in the other cases, because there was other litigation happening, the same thing happened. Just in this past week, you've got other district courts and a federal court, the Ninth Circuit Court of Appeals, saying, yeah, you know what? We still need this injunction to get complete relief. And one of the things for the states, which they said, and it makes a lot of sense, was like, how are we supposed to determine if a child is a US citizen if, for example, they're born in Arkansas and then they're brought to California? California's perception is if a child is born in the United States, they're a US citizen. And then how is California supposed to determine the citizenship of that child? Really, in order to, manage our own programs, our benefits programs, all the things, we're gonna need to know to have a universal injunction, which is basically a block across the country. So anyway, now we're in this posture again where you've got courts, lower courts, saying this executive order cannot go into effect. But what the Trump administration said to our judge and has said in other cases, well, we think it's still important to issue guidance. So we're going to have all these agencies tell us how would they implement this. So can you go to the next slide? So this is their interpretation. By the way, we were kind of guessing in the beginning as to whom this applies to, because the order basically says if the mother's not a US citizen and not a lawful permanent resident, but the father, oh, I don't know if this is quite right. Maybe I can just read it. You want to go to the next? Okay, yeah. Actually, you can take me off of the PowerPoint. Yeah. Okay. So children with a father who is a U.S. citizen, a U.S. national, or a lawful permanent resident, they're U.S. citizens. Children with a mother who is a U.S. citizen, a U.S. national, a lawful permanent resident, an asylee, that's someone who has won asylum, not asylum seekers. There's a lot of asylum seekers, they haven't won their case yet. Someone who has refugee status, a conditional permanent resident, or a Native American born in Canada who entered the US under a specific law. It's really, discrete. Those babies will be US citizens. Everybody else, no. And so what we're talking about is people with TPS, undocumented people, student visas, work visas, people with pending removal orders. Yeah, so there's a huge class of folks. And the guidance that the Social Security Administration basically has said, well, we're going to use our enumeration at birth program, which is this program. Like if you have a baby now, your hospital, records the birth and you file some paperwork with the Social Security Administration. It's pretty simple and you get the Social Security number. Okay, let me see. I see. If the mother or father is a citizen, then the child will be citizen. Yes, that's correct. And if the mother or father is a green card holder, the child will be a citizen. Okay, so what was I saying? Oh, the agencies. So you have USDA already saying for food stamps, WIC, all this stuff, they're going to require more paperwork. You've got the State Department saying we will need to see the parents' citizenship status in order to issue a passport to this baby. And so it's bizarre because, this executive order is not in effect, but you've got the fear mongering with all these agencies issuing this guidance. And one of the major problems is they're going to be relying on the Social Security Administration quite a bit. H-1B workers, yes, their children would not qualify because it's a temporary work visa. It's not a permanent visa. And we've been getting quite a few calls from H-1B and students. So the Social Security Administration's records are not reliable. The way that they know about citizenship is when people affirmatively tell them and have them update the records. And I know there's a lot going on in the government, so we would have to do FOIAs to figure out, what is like the accuracy of the Social Security Administration's data on parents. Okay. Is this just a slippery slope towards eliminating naturalized citizenship? That's interesting. Yes, I guess. I mean, I think it's like there's another piece of enforcement that they're going to be doing to limit naturalized citizenship. I mean, first of all, they're going to be looking at applications for not naturalized citizenship for fraud, and they're actually setting up a department to denaturalize people more. So this is related to that effort. And I think what you're getting at is, one of the things I've been saying, which is this is really about demographic change. We're becoming a majority minority country, and there is great fear amongst certain, white supremacist groups about that. And so the idea is one of the ways that we're going to limit access to this is just one in many tactics to limit access to citizenship. Yeah, so this is a great question about the LGBTQ parents. How would it impact that? I mean, we would have to probably litigate. I'm not sure how, because the guidance doesn't even address two mothers or two fathers. And I mean, I think it's all in line with the conservative agenda, right? They don't actually want to go there. So one of the things that's next is, okay, so let me just play this out. We've got the guidance, we've got the court saying that's not going into effect. At some point, this is going back to the Supreme Court on the merits. It's most likely in the next term, which starts in October. And then there will be oral argument, and usually they don't issue decisions till next June, but we'll see. We have no idea when, they will decide this. Oh, sorry, I'm sorry, you can't see the question. Okay, let me just finish and then I'll go back and I'll read the question. So our best guess is that the order will be ruled on in the next year. And in the meantime, it won't go into effect unless the Supreme Court does something different. If the Supreme Court says the order is constitutional, then we still have ways we may be able to attack it. And one of those is under the Administrative Procedures Act, which is that the guidance that the Trump administration is issuing is not adequate. And the implementation would be problematic. I hope we don't get there. I hope we don't get there. I don't know. I mean, I would have told you a few months ago that this is a slam dunk case. I think most lawyers would have told you the same thing. But given the way that this court is letting the Trump administration play games, I can't say what the Supreme Court will do. Okay, so now let me read some of these questions. If Trump's executive order to deny birthright citizenship goes into effect, then would the government do a mass denaturalization process, or would it be moving forward? It would be moving forward. They could not do a mass denaturalization process. And then the question I was answering before was, how would this impact children of LGBTQ parents? And I would say it's to be determined. But I think the focus is on the bio parents' status. What other questions?
Yes, Aarti, thank you so much. I know it's there are a lot of questions coming in. People have, yes, a lot of feedback. So one other question is, so the executive order is not in effect, as you mentioned, but some agencies are moving as though it is with these guidance documents internally. So what can folks in philanthropy and in other spaces do to best protect individuals and families?
Yeah, so I think, I mean, we have to do it all. Like we have an Equal Under the Law campaign at ALC that we're working on, which is we're going to work with local partners to ensure that people understand both their rights. Like, first of all, like the confusion is so palpable, and we've got to like make it super clear to people, you're okay. You're okay right now. Don't pay attention to this guidance for now, right? The hard part is like saying you're okay for now because we can't promise things, with this court. And I do think the lawyers and organizers have to work really closely together. That movement lawyering piece is so key. And that's what we're kind of that's what we're leaning into. And we have an FAQ we've just updated. It'll be for community. We translate it. It'll be on the Asian Law Caucus's website. We're finalizing it in the next day or two. So we can explain some of this. But a lot of this is making sure the community members are getting accurate, reliable information. And to know that, I mean, the hard part is we're going to have to invest in more complex litigation. We've just got to for us, it's really about trying to slow down all of this.
Thanks, Aarti.
Sure.
Okay, another question. If the EO goes into effect, how would the decision impact children who are citizens and receive U.S. passports before January 2025? What are potential implications for people who currently have DACA status?
Yeah, so DACA is temporary. and the children of DACA recipients would not qualify as U.S. citizens, and children who were born before. So it's children who are born before the executive order let's just say, whatever, next June 25th, the Supreme Court says Trump administration can implement this executive order, right?
Mm-hmm.
After that is all the babies who will be impacted, not before.
Okay.
It's not retroactive.
Okay. Thank you for that clarification.
Of course. Yeah.
So it's just because this is by design. This is the purpose, right? To
Yeah.
cause confusion and
Yeah.
instability, right? Yes.
Yeah. Gamesmanship. I mean,
Yeah.
that's the thing we have to remember. And, we scurry around like little rats, like, trying to. And so we're taking I'm trying to have a very kind of centered stance about this, which is like, okay, this is their strategy, and we're just going to keep hitting back. We're winning. We are winning in all of the lower courts.
That's a great reminder, because sometimes it feels like we're not winning. So
I know.
it's nice. It's really powerful to remind us that.
Yeah, well, this president claims a victory even when it's not.
I know.
So we have to remember we can win, and we need to organize. We need to let this court know what's important.
94% of the cases, that's in lower courts. Okay, that's great.
Yes,
That is a great
yes.
number. We need to, that is part of the narrative change to the narrative, right? That we are winning, even though it feels like all the attacks are coming, they're numerous, it's, an onslaught. And so remember this number, 94%.
Yeah.
Okay. Okay. Well, I know we're at time and want to honor Aarti and Ivy. Again, thank you so very much for just, being here, sharing your expertise with us and your time. As you can see, there's a lot of interest, a lot of questions, a lot of confusion. So this has been a really helpful conversation. So again, thank you. And then for everyone who tuned in, thank you all for just doing all you're doing to support our communities, for recommitting yourselves to supporting organizing, movement lawyering, all the things that we just talked about. It's easy to get overwhelmed, feel siloed in this work, but just remember you're not alone. There are organizations like GCIR, ALC, AAPIP, and we're here to connect funders with organizations, communities, so we can better resource our communities and support this advocacy efforts as we're continuously, figuring out how to navigate this landscape. So we at AAPIP, we have several timely programs coming up, including a 3-part leadership series. So please check out our website, sign up for our newsletter, consider becoming a member or renewing your membership to take advantage of some of those offerings. And on behalf of the entire AAPIP team, again, deep appreciation, Aarti and Ivy. Please take care of yourselves this summer. And thank you. Thank you again.
Thank you.